I, Sakshi Arora, Research Associate, International School of Business Management, Suresh Kyankar University, Jaipur. In the last lecture, we discussed about Indian Contract Act 1872. A contract is an agreement which is enforceable by law is known as the contract. What are the discharge of the contract? That means one party fails to pay or fulfill his obligation, his promises under the contract. So what happened and what are the modes available for the discharge of the contract? Let's see. Discharge of contracts meaning putting an end to the contract or termination of the contract. That means one party, both the parties putting that contract into end of the contract or terminate termination from the contract, that the parties are no more liable under the contract. Both the party are no liable for further performance or the further liability. So both the party are free from their contract. Termination of the contractual relationship between party is called the discharge of the contract. That means due to some reason, when one party fails to pay his obligation, they wants to terminate their contractual relationship. That means both the parties are known as the discharge of the contract. When the right and obligation created by it comes to end, that means during at the time when they are create the rights and obligation, that also comes to an end and both the parties are no more further liable for performing their performance, because it comes to end and termination of the contract. Types, various modes of discharge. First one is discharge by the performance. Second, discharge by agreement or consent. Third one, discharge by impossibility. Fourth, discharge by lapse of time. Fifth, discharge by operation of law. Sixth, the last one is discharge by breach of the contract. So let's see. What is the first? Discharge by performance. The party can also discharge the contract by the performance. Discharge of performance takes place when the parties to the contract fulfill their obligation arising under the contract within the time and in manner prescribed. That means both the party are performing their task that take the place. They are fulfilling their obligation that are arising, that are mentioned under the contract within the time. So there are two forms for discharge of the contract: by the performance, actual performance or attempted performance. Performance, we can take the example. There are two parties, party A and the party B. Party A gave offer to party B for sell his car, and party B accept that offer, and now they are both the parties are performing their performing that and take place when the parties to the contract fulfill. Also they are their obligation also comes under the contract within the time. So what are the two forms of discharge by the performance? First one is the actual performance, then that means when both the party perform his work. So let's understand this with the example. Anta and Kanta. Anta gave offer, put a proposal in front of Banta to buy his scooter on 50,000 rupees. Banta also accept that proposal and paid 50,000 rupees to Anta. So Anta is this now duty is to deliver that scooter to Banta. That means both the party perform his work under their obligation, under their rights, and the which is enforceable by law. Next, we have the attended performance tender offered to perform incomplete. That means when one party try to attempt that offer, but due to some reason, incomplete that offer, that contract. Let's understand the example. Anta and Banta. In this case, Anta gave offer to Banta for sell his scooter 50,000 rupees, and Banta reject that offer. So the one parties try to attend that offer, but it is not necessary when the promiser always put an offer in front of the promisee. He or she should always accept that offer. That is a depend on the situation. That is depend on the person. So we have the two modes: actual performance or attempted performance. Through that, that can discharge the contract. Next, we have discharge by agreement or the consent. When both the party discharge any contract by their agreement, by their mutual agreement, by their mutual consent, they can discharge, they can terminate that contract. So, what are the ways through that they can discharge the contract? By agreement or consent. There are two ways. It may be applied consent or by the express consent. What are the ways available in this? The first one is the mutual consent, like by the novation, rescission, alteration, remission, waiver, and the merger. Just as the contract is created by an agreement between the parties may also terminate or discharge the contract by fresh agreement by mutual consent. Like suppose both the party has create that contract or agreement with the mutual consent, but now due to some reason they want to terminate that contract, they want to discharge that contract, so they can also discharge the contract by the newly agreement, by the fresh agreement, by the mutual consent. Such an agreement may be express or implied. Section 62 or 63 of the Act provide for various modes of discharge of an existing contract by a fresh agreement. So these ways discharge of the contract by the mutual consent or agreements involved in the section 62 and the 63. First, we have the novation. What is the novation? Novation of contract means replacement. Replacement what? Replacement of an existing contract by another contract. So it is not like that ki you are terminated, fully terminated from the contract. You have to replace, you have to, that means you can see the substitution of the contract, of a new contract for the last one, that means the existing one. So novation of contract means replacement of existing contract by another contract. In novation, the parties may change. So it is not necessary for the new contract party should be the same. Parties may be changed, that is depend on the contract or the and their mutual consent. If the parties are not changed, then the fabric terms of the contract must be altered by the new contract. Both are the situation, that means that there may be the changes in the party or without changes in the party. So, by the new contract, because a mere variation of a number of terms of a contract is not a novation but alteration. So, novation is just like replacement, or you can say substitution of a new contract for the last one, for the previous or the existing contract. There are two types of the novation for replace any existing contract by another contract: changes in the party or without changes in party. Like, take the example of changes in the party. Changes in party, like person A booked a Ola taxi, you have heard about it, and booked a Ola for a ride, but you can see there is a when the person A booked the ride, the name show is the Ramlal, but the Ramlal, suddenly the person A see that the Ramlal is not pick up, rather than the Shamlal will be picked to person A. So the contract is terminated. That means they replace the contract, existing contract with the another contract. That means the changes in the party. Before, when he booked, person A booked the ride by the Ola. Okay, so he can see there ki Ramlal will pick, but after that he can see update in the that ride the Shamlal will pick him as a driver. So there are the novation. This is called as the novation. That means the changes in the parties. Without change in parties. That means, let's take the example. Whenever the contract is discharged without changes in the party. Suppose Anta and Banta. Anta make a offer to Banta sell his car on a 1 lakh rupee. But now, due to some issue, due to some change of thinking and whatever, Anta decided to sell his Activa instead of car. So that means he is replacement of an existing contract by another party. That means it is not necessary कि like maybe the parties may be changed, but in this case, in this example, parties are not changed, then the fabric terms of the contract must be altered. That means before he gives the offer about the car, but now he wants to sell the Activa. Okay, so it can be two types: changes in the party or without change in the party. This is the called novation. Recession. Recession means cancellation of the contract. That means cancelled by one party. It can take place in any of three ways. That means when a one party wants to cancel the contract due to mutual agreement, by failure to perform obligation, by agreement. How can a person can cancel the contract by the mutual agreement? Suppose, take the example. We understand it through the example. There are two parties, person A or person B. Person A gave offer to sell his laptop to person B, and person B accept that offer, and after the 15 days suddenly the person A informed to person B, now I am not ready to sell my laptop, and person B said that is okay, I am fine, it's okay. Okay, so that means both the party are cancel that contract by the mutual agreement. That means they are performing their obligations. Okay, through that obligation to the mutual agreement, they are rescission. That means they are cancel the contract by failure to perform obligation. That means whenever a one party is failure to perform his obligation under the contract, also the contract take the place as a cancel of the contract. Let's take the example. Anta and Banta. Anta gave offer to Banta to sell his car, and Banta also accept that offer. He is ready to purchase his car on a 5 lakh rupees, and Banta paid 5 lakh rupees to Anta. Now, his obligation, his duty is that he is responsible to deliver that product, that is the car, with the safely and on a time to the Banta. But he is failure to perform his obligation. He didn't deliver that car. So Banta has a right. Banta can claim for that his amount. He can also cancel the contract because due to failure to perform obligation by aggrieved party. If the aggrieved party, that means the promisee, wants to cancel the contract, they are not uh, they are not performing their obligation under any contract. So that means it take place the cancellation of the contract. So we have the three ways of the cancellation of the contract: by the mutual agreement of both the parties, by failure to perform obligation, by aggrieved party. Alteration. Alteration of a contract takes place when one or more of the terms of the contract are changed. That means in the contract there are so many terms, terms takes place, and there are so many alteration. That means the changes in the contract. So that is known as the alteration. If a clause alteration in an exceedingly written contract is formed with the consent of all the parties, the initial contract is discharged by alteration and a brand new contract takes its place. That is depend on the obligation, that is depend on the alteration. An alteration could also be a change within the amount of cash. What are the conditions? What type of the alteration may be take place in the contract? That is the amount of the cash, speed of interest, name of the parties. In such case, the old contract could also be discharged. Means a change in one or more of the material terms of the contract. So there are two parties. Let's take the example. There are two parties, party A and the party B. Party A promised to party B, party A promised to party B deliver 100 TV set on 15 October. Okay, and instead of 15 October, there is some alteration. Now, party A will be delivered that 100 TV set on 30 November instead of 15 November. So there is an alteration. There is an alteration in the date, delivering date. So it may be amount of cash, speed of interest, name of the party, anyone can be. So there are alteration. That means contract take place when one or more of the terms of the contracts are changed during the contract. That is known as the alteration. Two types. It can be two types: material alteration and the immaterial alteration. Material alteration is one which is alter the legal effect of the contract. That means change in the amount of money to be paid, rate of interest, or the name of the parties. Like suppose material, like suppose person A borrow 5,000 rupees from person B, and he promised I will return this amount within the 1 month. And within the 1 month he fails to pay and return that amount to person A, to person B, and so that means there are some changes, there are some alteration in material alteration between both the party through their mutual consent. Now A has to pay 2,000 rupees instead of 5,000 rupees. So there is a changes in the amount of money to be paid. Before he has to pay the 5,000, but he fails. So the mutual consent from between the party, now he has to pay only the 2,000 rupees instead of the 5,000 rupees. Immaterial alteration, it is correcting a clerical error in figures or the spelling of the name. Like in the contract, there is a correction like due to the clerical error in figures of the like amount put the wrong, and there is the spelling, name of the person spelling are wrong. So there, that is known as the immaterial alteration. What is the difference between the novation and the alteration? Both are in the listening is similar, but there is some difference. In the novation, changes in the party, but in the alteration, party remains same. Only the terms on the fabric are can be changes. There is a alteration can change the place, take the place. In the novation, all contracts is dissolved by new contract. That means the substitution of existing with a new one. Rather than there is a no dissolution in the alteration, there is changes terms of the material or the immaterial take the place in the alteration. Novation, two types of the contract. Rather than in the alteration, there is one type of the contract. Remission. Section 63 allows remission is acceptance of lesser amount than what was contracted or lesser fulfillment of the promise made. An individual who feature a right to demand the performance of contract may be remit or hand over the full part or a part of a debt, extend the time of the performance. That means remission means accept of lesser amount than what was the contract or lesser fulfillment of promise made before the between during the contract time. Let's take the example. Person A. Person A borrows a 50,000 rupee from the person B and promise I will return this amount after the 15 days. After 15 days, due to some financial condition, person A fails to fulfill his obligation during the contract. Is not able to pay that amount, return that amount. So in this condition, he has two options. He can hand over the full, that means he has to pay the full amount, that means the 50,000, or maybe the part of the debt. Like he can only accept uh, that is depend on the party B. If he said ki, I am ready to part of a debt, like he can also remit that he can allow him for pay only the 30,000 instead of the 50,000, or another he can also extend the time for the performance. That means I will give you the 1 month for the performing your obligation. So that means I am extending your time for the performance. After the 1 month, please return my amount with the interest and the all. So these are the two options for the remission. Waiver. Waiver means the abandonment of a right which a person is entitled to, means abandoning the rights. When a party waives his right under the contract, the other party's release of his obligation. That means give up. Waiver means the give up. When a person give their right, so another party is also released from his obligation, like person A and person B. Person A give his car to person B for a repair. Okay, so the person B is responsible to repair his car, return with the safety, and person A is responsible to pay what are the charges for the repairing that car. Okay, this is the performance. But take another example. Person A promise to person B, I will paint your picture, but due to some issue, he is not ready to paint his picture. So that means a person B never forced to person A to paint his picture. Now the party waived his right under the contract, so the person B is also released from his obligation. So that means give up. Third one is discharge by impossibility. If an agreement contains an undertaking to perform an impossibility, it is a void ab initio. Like contract, that is the capacity to come into the contract, that should be recognized what is the impossible. So impossible, that means the possibility should be there. Like take the example, there are two parties, person A or the person B. Person A gave offer to person B to sell his car, but in that car, due to accident, that car was damaged. So now the perform an impossibility. There is Okay, so that's why the discharge by the impossibility, the contract will be discharged, contract will be termination because the subject matter was destroyed. That means the car was damaged in the accident, so it is impossible to perform or continue that contract. Like India China war, we can take another example. What are the rules discharged by the impossibility? Lacks non-cognate ad impossibium, that means a law doesn't recognize what is impossible, that is defined. True. Impossibium nulla obligatum, that means what is impossible does not create an obligation. These two rules, that is based on the discharge by the impossibility, that means the subject matter was destroyed, is not existing between the contract, so how the possible to continue the contract to perform that contract? Impossibility, we have the two ways. Impossibility existing at the time of the agreement, you can say the pre-contractual impossibility. Like in that case, we have the two parties. First one is known to the parties and unknown to the parties. When the parties, there is a contract between A and B, and party A, there is a contract, and he said he to put life into the dead wife. How is it possible? Because they know that no one can live give the life to the dead person. That is a known between the parties. Unknown to the parties, that means there is a contract between the X and Y. X will deliver the some goods through the ship and to the Y, but both the party doesn't know that ship will be sunk and the product cannot be delivered. That is because unknown party, both are the unknown due to the situation, that impossibility. Second, we have the impossibility arising subsequent to the formation of contract, supervening impossibility, post-contractual impossibility. That means the many. That means a person A, uh, B, there is a merry contract between the person A and the B, but due to sound mind, or you can say the person A gone mad. So how is possible to do the marriage? Because they know there is an impossibility between them. Post-contractual impossibility. Destruction of subject matter of the contract. Non-existence or non-occurrence of a particular state of thing. Death or incapacity of personal skill. Change of view. Restriction of subject matter of the contract. That means whenever the contract is making for a particular subject matter and the subject matter destroyed and restriction of that subject matter between the contract, so how to possible to perform that contract, to complete that performance? Let's understand through the example. There is a contract between person C and the person T. Person C gave music hall to person T for some specific event on a specific occasion. But due to heavy rain, that music hall was destroyed. So now the restriction of the subject matter, that means the for what they making the contract, what are the subject matter, and the subject matter is not existing. So how is it to possible to perform the task, perform the event and that particular music hall for them? So this is also the another reason for termination of the contract between the parties. Non-existence or non-occurrence of a particular state of the things. That means person A and the person B has a contract, create a contract of the marry, and person A one married. So how is it possible? Because the person B already know we cannot marry with the person A. Rather, it is a contract or whatever the promises. But now he is free from that obligation because before, during that contract, person A is proper the sound mind, that is not the unsound mind, or he or she is not the mad. So now he can particular state of the thing is not available, so he can terminate that contract. Death or incapacity of personal skill, that means like any, due to death, due to incapacity, or any personal skill is not available, so how to possibility of perform that contract, it is impossible for them. So let's understand through the example. There are two parties, person R and the person B. R is R gives the offer to sing at a theater with a T, but now after the at the same time R is unable to perform because of illness. So due to illness, due to incapacity of the personal skill, he is not available, he cannot perform his obligation, he cannot fulfill the obligation under the contract, so the contract take the place as a termination. Change of law, that means any changes in the law, that means by the government or by the company or whatever. So let's take the example A and is, that means A S buy goods, that means a wheat from the A, and wheat lying in the go down is as said before, after the 15 days please deliver these goods in at my place. Before the delivery go down was sealed by the government, contract is discharged as the delivery of wheat become impossible because the go down was sealed by the government. Okay, so that means there is change of the law. So that means it can also the take of the place, discharge of the contract. So it is a very difficult for these are the various modes we can say the person can discharge the contract. We can see here like what are the ways we read in this: discharge by the performance, discharge by the agreement or consent, discharge by impossibility, discharge by lapse of time, we will read in the next one, discharge by operation of law, discharge by breach of the contract. So we can see like discharge by performance is like it takes the two form: actual performance, attempted performance. In the discharge of the agreement, it can be also by the novation, by the rescission, by the alteration, remission, waiver, or the merger. That is depend like they can discharge by the agreement or the consent between the mutual agreement, mutual parties. Discharge by the impossibility, it also take the place. We know discharge by the impossibility, discharge like whenever the known to the parties, unknown to the parties. So that is depend. And impossibility arising subsequent to the formation of the contract, supervening impossibility, post contractual impossibility. We already understood it through the example, like maid example we take, theater example we take also for that. So these are the ways they can discharge the contract. But whenever the one party discharge the contract, one what's about the other party? How can he or she will bear the loss? So for that, don't worry about that. For that, remedies are also available. What type of the remedies are available? Remedies we will see in the next lecture. Ki if the one party break the rules and fails to perform his obligation under the contract, like it may be the due to the restriction of the subject matter, non-existing of a particular of a state of thing, for that they have particular make the contract, like death or incapacity of a personal skill, change of law we can see. So these are the ways the person can the contract can take the place as a termination. So in the next lecture, we will see what are the other various or modes of discharge of the contract. Thank you.